Good morning, everyone, and welcome to today's webinar, Colombian Competition Law Made for Simple Infrastructure Investors from China. My name is Felipe Quiroga, and I'm pleased to represent the Colombo-Chinese Chamber of Investment and Commerce. We are delighted to have you with us today for this insightful session organized in partnership with our member company Competencia Legal. The Chamber's mission is to strengthen the business and investment relationship between China and Colombia. Through spaces like this, we aim to provide practical guidance to Chinese companies and foreign investors exploring opportunities in our country, Colombia. Today's session will provide a clear and practical introduction to Colombia's competition law, particularly in the context of infrastructure projects and public procurement. To lead us through this important topic, we are honored to welcome Mr. Ismael Beltran Prado, competition law expert and partner at Competencia Legal. Mr. Beltran has extensive experience advising both local and international companies on competition, compliance, regulatory affairs, and we are very grateful to have his expertise with us today. Before we begin, just a quick reminder for everyone joining us online. If you have any questions during the presentation, please feel free to leave them in the chat. We have a dedicated spot for leaving the questions in order to provide answers later on. We'll dedicate a few minutes at the end of the session for a Q&A segment. Mr. Beltran, the floor is all yours.
Thank you, Felipe. Thank you very much for the introduction, and thank you very much for joining. Are you hearing me?
We hear you quite well.
Okay, so I'm gonna share. I think I already shared. Let me see my screen. A second. Let me know if you are. No, you're not seeing. Really.
Yeah, we're seeing it. Everything is all right.
Okay, so let me. Sorry. Are you seeing? Are you watching the presentation or not?
Yes, sir.
Okay, thank you very much. So, put this here. So thank you very much for joining us. As Felipe mentioned, we're going to have a short introduction on competition law. This seminar is dedicated for Chinese companies interested in investing in Colombia, particularly in infrastructure projects. But this presentation will be also useful for Colombian companies interested in joining Chinese companies to participate in infrastructure projects. So as you will see, it's very important to have a quick understanding of what Colombian competition law is in this context. This is going to be our agenda, but let's begin. So it is not a secret that China is emerging as a very important partner for Colombia and for Latin America. There is a clear economic and geopolitical shift, and China is gaining a lot of momentum in Latin America and particularly, I believe, in Colombia in the following years, since the country, as you may know, signed with China the Belt and Road Initiative, which I believe will open a space for more investment in the country. So this is kind of the beginning of what I believe it's going to be huge investing from China, more cooperation and the deepening of a long-standing relation. And as you know, China and Chinese companies have a lot of expertise in infrastructure, and Colombia may take advantage of that. So yeah, I was mentioning why it matters for Colombia. Colombia needs to update its infrastructure. It is not a secret that we have a deficit in infrastructure in the country. So China could be a great partner to this end. And China has not only the expertise, but also it has the capital. Here you can see the image of the metro system that is building a Chinese company here in Colombia, in Bogota particularly. So yeah, but as it happens in many other jurisdictions, Chinese companies may encounter some regulatory challenges when entering into Western markets. And it will happen, it could happen as well in Colombia, and I believe in other Latin American jurisdictions, because there are some, of course, some differences between competition law in China and competition law, sorry, in Colombia. So it's important to have this introduction. It is important to bear in mind that infrastructure projects are usually conducted as a competitive process. You know, competition law or competition is the rule for public procurement, and as you know, public procurement infrastructure projects, sorry, um, are usually conducted by public procurement in Colombia. And because those processes should be competitive, there's a strong relationship between competition law and public procurement. So let's get deeper into this to know how to tackle some of these challenges that might arise when entering into the Colombian market. First of all, it's important to have kind of a quick understanding of or comparison, if I may say so, between both regimes. Both countries have competition authorities. Colombia has the Superintendence of Industry and Commerce, which is a national and centralized authority that surveils the market in Colombia. It is important to note that the Colombian Competition Authority has not only the duty to surveil competition in the markets, it has other functions related to data protection and consumer law. I mentioned that because for some people that might be a little bit confusing, like the competition authority having many other functions. As in the case of China, currently there is the state administration for market regulation. This is before this was the case. China has many other authorities that were protecting the market in China, but currently those functions are also kind of unified in this entity, public entity. As to the case of Colombia, as I mentioned, the Superintendence of Industry has many functions, but in the case of competition law, there are some departments within the authority that conducts the investigations. So there are kind of two important departments to have in mind. The first is there is an elite task force within the superintendents in charge of helping the deputy superintendent for the protection of competition to conduct the whole investigation. And at the end of the investigation, the deputy superintendent for the protection of competition issues a recommendation to the superintendents of industry and commerce, who is in charge of deciding if there has been competition law violation. So it is important to know that within the Colombian Competition Authority, we have these public officials, public officials conducting the investigation. And I believe that it is important also to have some idea of how the process works. I believe this is important to note that in any case that a Chinese company or a Colombian company in partnership with a Chinese company for some reason is investigated, it is important to note that there are many opportunities within the process to defend themselves and to know a little bit about the process. The process, because the Superintendence of Industry and Commerce is an entity belonging to the executive branch of the state, this process is administrative in nature, and I should highlight that it is also conducted or is respectful of the due process. It is ruled by the due process. So that's kind of a safeguard for investors. And as I mentioned, the investigation is conducted by the Superintendent for the Protection of Competition. And at the end, when the whole investigation is conducted with the help of this task force that I mentioned, the superintendent make or take a decision and decides whether the competition law has been violated or not. It is also important to note that if a party is penalized or is sanctioned by the superintendent, that party has the opportunity to request a review or a reconsideration of the decision before the superintendent. And at the end, if the superintendent holds its decision, the party has the chance to go to the courts to challenge those decisions. I should highlight that that's important as well. That judicial review in Colombia regarding the protection of competition is very active. So investors can have the can have the can have the tranquility that they may have many chances to defend it themselves if for any reason they are investigated by the Colombian Competition Authority. And just to mention kind of a little bit of, to make a little comparison, under the Chinese law, the anti-monopoly law of China, AML, the Chinese authorities also conduct down rates as it is the case in Colombia. So the Colombia Competition Authority has the power to conduct down rates, and they have huge powers to do so. And yeah, the Colombian Competition Authority, as well as it happens in China, has the power to request information, to surveil computers, to get into into the company's headquarters to request information and to gather information. That's something that is important to have into account. And in the case of China, it happens the same thing. And also the Chinese authorities have the chance or the opportunity or the power, sorry, to suspend or end any investigation. In Colombia, it is important to know that the Colombian Competition Authority has also similar powers, but in practice, I believe that the Colombian Competition Authority usually conducts the investigation until the end. It is not very, it is rare actually when the Colombian Competition Authority, for any reason, suspend or end an investigation in a prematurely way. So that's something that you have to take note. And in addition, as I was kind of comparing both regimes, I would say that in the case of Colombia, that the state has an important role to play, of course, but in China, the state plays a preponderant role. Here are the laws that govern competition law in Colombia and China. As to the anti-competitive conducts, I believe that both regimes have similar conducts, being the most important ones, anti-competitive agreements. In the case of China, they are called monopoly agreements. And of course, the abuse of dominant of the market position, it is the Chinese regime has also that conduct. As to the exceptions, in the case of China, I note that they have more exceptions, but in the case of Colombia, exceptions to the application of the competition law are rare and are few and rarely applied. Okay, so that's something that is important to have in mind as well. As to the objectives, well, in Colombia, the objective of the law is to protect the market, and the Chinese law says something similar, but by saying to prevent and restrain monopolistic practice and protect fair market competition. The Chinese law also emphasizes on the importance of innovation, and both regimes also highlight the importance of attaining efficiency, economic efficiency. Both regimes are intended to protect consumers. In the case of Colombia, the wording is to protect consumer welfare. And as to the whole objective, if I can refer to, as in the case of Colombia, the law says that the objective is to protect the market as a whole. And in China, the AML says that the goal is to promote a healthy development of the socialist market economy, which is a philosophical difference which I deem is important. It is also important to know that the Colombian courts, or in particular the Constitutional Court, has referred to the market in Colombia as a social market economy. So there are some similarities that we can highlight between both regimes. So why does competition law matters for infrastructure projects? And as I mentioned, the state leads the provision of public goods and services, and these services usually are provided through through public procurement, through open tenders. And these tenders and the process of the public procurement in Colombia must be competitive. And in order to have a competitive process, the competition law protects the procurement process in order to make it competitive. So I would say that there is a close relationship, a very close relationship between public procurement and competition law in Colombia, because competition law, if I may say so, kind of helps the public procurement to achieve its goals. Competition law, as you may know, helps because of the competitive process, helps to reduce the costs of contracting for the state. So it benefits the states and the citizens, and it encourages the provision of higher quality goods and services. The competitive process helps to do particularly this. Okay, and in this journey of understanding the Colombian competition law regime, I always highlight the importance of knowing very well the principles of the public contracting law in particular. And as I mentioned, because the public procurement and the competition law are closely related, these principles usually apply to the competition law. So I will mention some of these principles, and I will highlight particularly those that I deem are most important for the application of competition law. So let me just follow through these principles, to go through these principles, sorry. The principle of transparency, the principles of efficiency, the principle of accountability. These other principles are contained or in the Colombian Constitution: the principle of equality, morality, effectiveness, efficiency, promptness, impartiality, and publicity. And as I mentioned, I would like to center the attention on those principles I believe are more important for the competition law. And the first one, I believe, is the principle of equality, which says that all bidders shall be treated as equals, and they should be allowed to bid in equal conditions. So under the Colombian competition law and under the public procurement law, every competitor must have the right to bid. I would say that the principle of equality is kind of a very important prerequisite to participate in public procurement in Colombia. Other principles that are also important is the principle of impartiality. The public entity should be impartial in front of all the competitors. The principle of publicity, which allows competitors to access the process, to have the information, to have open access to the information that is important for the participation in a public tender. The principle of transparency as well, which kind of comprises all the other principles of impartiality, equality, and publicity. Um, and it says, or it states that the process, the public procurement process, should be free of capricious and arbitrary considerations. And one principle that is very important is the principle of objective selection. I'm not sure if this is the right translation into English, but it says that the public entity should select the most advantageous bid based on only technical and economical factors, not on if I may say so, accidental factors that are not relevant for the process. So always bear in mind these processes, and for Chinese companies, it might be also helpful to note that under the AML, sorry, the principles can be derived as well from that law. If you see Article 42 of the AML, it says, or it states, that administrative organs and organizations authorized by laws or regulations to administer public affairs shall not abuse their administrative authority to exclude or restrict undertakings from participating in bid inviting and bidding activities or other businesses activities and cities by means such as setting discriminatory qualification requirements or evaluation standards, or not publishing information in accordance with law. So, well, I believe that principles are always useful in law, but are also useful for Chinese investors to know those principles in order to invest here in Colombia. So let's get deeper into the main topic, which is what are the conducts that Chinese investors should take into account when entering the Colombian market. So know that the Colombian competition law condemns the sole threat to competition in public procurement. So the sole threat could be investigated and punished. This is kind of a per se rule that is applied in other jurisdictions such as the US. And it's also important to bear in mind that the Colombian competition law comprises a wide range of conducts that are deemed anti-competitive. So the most important conducts that any competitor, and particular Chinese competitors, must take into account when entering the Colombian market are this. The first one is what we call the general prohibition, and the conduct that condemns bid rigging. As to the general prohibition, which is one that I believe that Chinese investors should bear in mind and follow very closely, it is important to know that this rule is very open in texture. It prohibits any practice that restricts competition, so it allows the competition authority to investigate a wide range of anti-competitive conducts. And this section of the competition law has like three parts, which I would not enter into the three parts of this section. I just want to highlight the most important for our ends, which is to highlight the most important part of the article related to public procurement, particularly for infrastructure projects. So the part that I believe is important to highlight is the one that is in the middle of this part of the presentation, which says that any kind of practices, procedures, or systems intended to restrict free competition. So as you may note, that's a very open clause which protects competition, and that gives the Colombian Competition Authority a huge power to investigate many conducts that may be deemed anti-competitive. Okay, so and I particularly of this article or something that Chinese investors should focus on, and I will speak about this later in a little in some in a couple of minutes, is the concept of control. It is very important to have this in mind for Chinese investors. What is control? Control. Let me read this from the law. Control is the possibility or of directly or indirectly influencing corporate policy, the initiation of termination of the company's activities, changes in the business activity to which the company is dedicated, or the disposition of assets or rights essential to the development of the company's operation. In short, what this control says is that one company has the possibility to influence, to guide other companies, in the sense that, or let me correct this a little bit, to have the power to make a company do something in the market. That's kind of control. It's the possibility to guide the competitive conduct of a company in the market. And what of course you should focus on is to avoid any kind of anti-competitive control. Why is that? Because when two companies are competing for a public in a public tender, um, if two companies are competing and both of them are controlled by a same company, this might be considered anti-competitive under the Colombian law. So let's take a look at how does this conduct look like. For example, if we have company A, which is the company that is controlling company C and company D, and there's another company B, which is not controlled by company A. So we have this public tender right here, and company A controlling company C and company D. If this is the case in a public tender, in an open tender, for be aware for competing for getting um, um, a, a public contract in infrastructure, for example, the Colombian Competition Authority might consider that company C and company D are not totally independent, so that they are not totally, or they're not capable of competing for gaining a particular contract. So when we have two companies controlled by one company, we cannot say in principle that these two companies are independent. And there's for competition to be deployed, companies must have the possibility to be independent in the way that they may define the prices, the quality of the goods, and etc. All how they will be competing in the market. Again, if one company controls both companies, it is difficult to those companies to be independent. So why is this very important for Chinese competitors? I will I will I will come back to that topic, but bear in mind that this is a very important conduct for the Chinese context. As I mentioned, there is another conduct which is in the Colombian law, as it is also in the Chinese AML law, which is the collusive tendering or bid rigging, which is forbidden under Colombian competition law. This is not the case to enter into the many ways which this conduct may be deployed in a market. But just to mention a few examples, though those conducts that are considered anti-competitive is the so-called cover or symbolic bidding. When some bidders submit fake high or flaw bids, and they know that those bids will be rejected. That's not a truly competitive process. The bid suppression is also a way in which companies may violate competition law. This is the case when some companies agree not to be bid at all. So only the selected competitor, which is going to earn the contract is the one that only the one that bids within the or during the public procurement process. Bid rotation, bidders take turns for winning contracts. Market allocation, when companies divide the market, for example, by area. These are all many ways in which bid rating, may be deployed in the market. So how does this conduct look like? This conduct would look a little bit different. It would be like it's a horizontal agreement. It's an agreement between company B and company C, which, as you may note here in the graph, company B and company C, because they have this agreement, they're not independent before within the public procurement process. So this might also be deemed anti-competitive under Colombian competition law. In addition, it's important to note that under Colombian competition law or under the criminal law, the bid rating is a criminal offense. So it's important to take that into account. So why is this important for Chinese companies? I think the most challenging aspect for Chinese companies is the so-called Chinese state-owned enterprises, which, as you know, are legal entities owned or controlled by the Chinese government. And these companies might have some regulatory challenges, as I will mention. So why particularly? I believe that the most pressing issue for these kind of companies would be the general prohibition that I mentioned before. And this is particularly important for infrastructure companies. So let's take an example to understand why this could be challenging. Let's say that a Chinese two Chinese companies, let's say Chinese SOE A and Chinese company or SOE B, are controlled by a third entity or by a public entity in the case of SOEs. So that would be challenging in the sense that other competitors might question the fact that two companies are owned by a public entity. And those competitors might believe perhaps that these two SOEs are not independent to compete for a particular or to compete in a bidding for an infrastructure project. Does this mean that these companies are not allowed to participate in the Colombian market? Not at all. But it's something that I believe will be very sensitive for Chinese companies, particularly for those that have the participation of the Chinese state. So what to do? So I believe that there are many things to do, of course. The first is to be conscious about this possible issue when entering and competing for public procurement processes in Colombia. I would recommend to those SOE companies, and in general to any company, because as I mentioned, not only SOEs can be controlled by the state, but two companies might also be controlled by a company that is upon them. So this is something that all the companies, not only Chinese companies, but also Colombian companies should take into account. So first of all, what I believe they should do is to conduct kind of a due diligence if there is a conglomerate which is a huge conglomerate might be very complex. So the first thing to do is to be very aware of the conglomerate to know where the control might be. In addition, it's important to review the bylaws of all the and ownership of all these companies to make sure that the control companies have the possibility to be independent when competing for public biddings or open tenders in a jurisdiction like the Colombian one. I would recommend also that it is important to obtain a certificate of independent bid to make sure before the Colombian Competition Authority and before the public entity that is conducting the public procurement process that even though two companies have or have the participation of the state when competing for a public procurement process in Colombia, they are independent um, for a particular bidding process. So you should obtain the certificate and of course make sure that in practice these two companies, if that's the case, that's something that is not going to happen in every public procurement process, but might be the case. To make sure that this certificate is kind of a safeguard for those companies that they are independent and they can bid and compete for a particular public procurement process or for a particular bidding tender. I would recommend also that you have that to train your staff in a basic understanding of antitrust or competition law, and in general, as usually it is usually so the large infrastructure projects have not many competitors because they are so huge that are not many competitors have them the the capital and the expertise to participate in these large infrastructure projects. So bear in mind that perhaps many competitors may share many common places in the markets. So what I would recommend is to restrain from for interacting with other competitors, particularly before or during a bid, an open tender, because this might raise, that may raise some worries for the Colombian Competition Authority. It is not that it is forbidden, of course, to speak with other competitors, but when facing the public procurement process, I would be very cautious to avoid any misunderstanding. Um, and also, this is also a caution that you should take into account when having informal meetings in industry gatherings. Particularly in those those moments or those moments before and during the public procurement process. And and as well, I would recommend to have a robust compliance program before participating in any public procurement process, to make sure that you have incorporated all the cautions that a company must have before competing in the Colombian market. And this is very important. It's very important that you make sure that your company, when communicating with the public entity, if that is required, always make sure that you use the official communication channels, and avoid any external communication with public servants belonging to the public entity that is conducting the public procurement process. So just to close a little bit what we have said today, I would say that China and Colombia have a historic opportunity to strengthen their economic ties and cultural ties, of course, and for Chinese companies would be very important to make sure that they comply with Colombian law, taking into account the differences that both countries, the regulatory differences that both countries have. So it is important to have this basic understanding of Colombian competition law and public procurement law to make sure that that you have a soft landing in the country. I would highlight that both laws have some similarities that are important to consider, but of course there are some differences that are also important, particularly regarding the SOEs that I believe is could be challenging when entering and competing for a public for a open tender in Colombia. Remember always that public procurement and competition law are closely related. Um, Remind also that the Colombian competition law has covers a wide range of anti-competitive conduct. So is the law is very flexible in investigating, to give powers to investigate a wide range of anti-competitive conducts. And in this context, it is also important to highlight that the Colombian Competition Authority also has a broad powers to investigate and punish anti-competitive conducts in the Colombian market, and particularly in the public procurement. And yeah, it is also very important to bear in mind that many anti-competitive conducts might be investigated under a per se rule. That means that the Colombian Competition Authority might deem that a conduct that has the potential to harm the competition might also be anti-competitive, which we as in the way that other regimes um, consider this conduct as a per se rule. So the sole potential of harming competition could be investigated and punished. So take that into account when preparing a bid during a public procurement process. So that would be the short introduction to the Colombian competition law. So if you have any questions, I'm happy to answer any question that you might have.
Well, thank you very much for your presentation, Mr. Beltran. We do not count with any question dropped in the Q&A box, so this might be the end of the webinars. We hope this session has given you a clear understanding of Colombia's competition framework and how it applies to infrastructure investments. Before we close, we'd like to remind you that the recording of this webinar will be available on our official YouTube channel, and it will also be sent to the email addresses you used to register to this webinar. On behalf of the Colombo-Chinese Chamber of Investment and Commerce, thank you once again for being part of this event. We look forward to seeing you in our upcoming activities and webinars. Please have a nice day.
Thank you very much. Pleasure.